Hello and welcome. I'm Amritan Shira and you're watching Law of the Land on Sabha TV. Today we bring to you the Supreme Court judgment barring admissibility of scientific evidence from tests like narco analysis and brain mapping. Which has been obtained forcibly. To discuss the issue, I have with me Dr. Bivarani Ray, former Director CFSL, Mr. Sanjay Hegde, Advocate in the Supreme Court, Dr. Sanjeev Lalwani, Associate Professor, Department of Forensic Science, Trauma Center, AIIMS. Now for the headlines. The Supreme Court rules that scientific tests without consent is unconstitutional. It says there is no compulsion for anyone to give evidence against oneself. And the Supreme Court highlights the life-threatening impact of these tests. The Supreme Court has ruled that use of narco analysis, brain mapping and polygraph tests on accused without their consent is unconstitutional and violates privacy. It said that no one can be forced to give evidence against himself.
The Supreme Court in its judgment said one of the main functions of the court is to safeguard the interest of the citizens in their interactions with the government. As the guardians of these rights, we will be failing in our duty if we permit any citizen to be forcibly subjected to the test.
As evidence in a criminal trial to convict an accused person. It's a landmark judgment, true, but a little late. Because many Supreme Courts and many constitutional courts in this country years ago held that the truth serum tests, the narco analysis tests, were in fact a kind of torture. Because while administering these drugs, the accused sometimes experiences excruciating pain.
The court in its judgment said test results of narco analysis, polygraph and brain mapping test results cannot be admitted as evidence if they have been obtained forcibly, as no accused can be forced to give proof against himself. The judgment said no one should be forced to undergo any of the tests, whether for investigation or otherwise. But the court left room for persons who would like to voluntarily undertake such tests subject to certain guidelines. The court says that no lie detector test should be administered except on the basis of the consent of the accused. If the accused volunteers for a lie detector test, he should be given access to a lawyer. The consent to undergo test should be recorded before a judicial magistrate. The actual recording of the lie detector test shall be done by an independent agency.
So as far as my personal view is concerned, so for narco analysis, the consent should be recorded in front of magistrate. But as far as polygraph and brain fingerprinting, so both are non-invasive technique and the subject is very much comfortable. And these machines, the polygraph machines, measures only that behavior that is controlled by the autonomic nervous system. And no drugs induced. If the expert is also taking, so it's correct because both techniques are non-invasive technique.
The petition was filed in the Supreme Court questioning the administration of scientific techniques for the purpose of improving investigation efforts in criminal cases. The argument extended was that it will minimize the use of third-degree methods resorted to by the investigators to obtain evidence.
This judgment is based on a basic principle of criminal law, that is adversarial system, where there is a presumption that accused is innocent and burden of proof is on prosecution. With camera person CV, Aruna Thakur, Rajya Sabha TV.
Not only does an accused person have the right to refuse to answer any questions that may lead to incrimination, there is also a rule against adverse inference being drawn from the fact of his/her silence. Ma'am, the question to you is, the point that was made, polygraph and brain mapping tests, these two do not involve administration of intravenous chemicals or whatever, materials. In view of that, do you think this should be allowed as part of investigative techniques in the present system that we have?
Yes, you have to have some tool to investigation, scientific tool to investigation, and to talk to the persons involved in a crime scene is the best method of getting at the facts of the crime that has happened. So, in order to have the investigating agency has to take recourse of some scientific methods, and I think polygraph examination and brain mapping, they are non-invasive technique, and they can be used as scientific aid to investigation. I don't say that results should be taken into evidence as such unless there is a corroborative primary evidence to it. But it has to be used, there has to be some method of investigation.
Sanjay, the question I would like to put to you, has the court in its judgment differentiated between the three types of tests, and if it has, then has it made a division between narco analysis and polygraph and brain mapping in one side and narco analysis on one side? First. Second, what is going to be the real impact on investigators of this entire judgment, where they've said clearly that it can't be used as an investigative method at all?
It is not that it cannot be used as an investigative method. You cannot force anyone to subject themselves to such a test. So supposing a suspect voluntarily says, do a narco on me, or I'm ready for a brain mapping or even a polygraph, then any evidence discovered after this test, primary evidence discovered after this test, would be admissible under Section 27 of the Evidence Act. These tests are basically investigative tools. The question before the Supreme Court was, are there the constitutional guarantees against self-incrimination under 23 of the Constitution of India, or the right to privacy, which the court has already read into Article 21 of the Constitution of India? Do they in any manner come to the aid of the accused or the suspect, and can he be forcibly administered this test, or can he without his consent be subjected to such tests? There the court has now come down on the side of the citizen, because any citizen could be accused of anything at any point of time. And if a citizen is to be compelled to undergo such tests on the pain of adverse inferences being drawn against him, the court said that is unconstitutional.
Does it compromise investigation activities?
Well, an investigator will then have to go on the footing that he cannot compulsorily administer these tests. He can go on, he can probably induce the suspect, he can persuade the suspect. If the suspect gives his consent, yes. But if the suspect does not give his consent, you cannot compel him. Then you have to go on the footing that you are not going to get anything from the suspect. Let us go and find primary material without such a test.
Dr. Lalwani, the impact, the court has said that it has got, and especially on the difference between the narco analysis and polygraph and brain mapping, where these two are non-invasive, the other one is otherwise invasive. On that front, do you think the differentiation should have been made? Because that is how it is everywhere?
No, as far as you see medical aspects are concerned, medical practices basically run with few principles of ethics, like beneficence, non-maleficence, autonomy, justice and sanctity of life. It means in medical science, whatever procedure you do for the patient, it will be for his benefit, not to harm him, and then patient has right of autonomy under Article 21 of Constitution of India. So patient has right to choose what is right for him, and ultimately it should benefit him. Our aim is not to cause harm to him in any means. So court has gone through that principle that every test has to be done with consent on voluntary basis. Until unless person himself volunteers for participation in this test, these tests cannot be constitutionally valid.
Okay. Dr. Ray, the point on the differentiation, anything that you would like to add? The doctor's point of view is clear, the legal side is clear. On the differentiation technically, because you've been director of the CFL, you know how investigation is supplemented or supported by the CFSL. In that thing, do you think the differentiation should have been made?
See, first I will like to answer his question about the voluntariness, because court has insisted on voluntariness.
Yeah.
Let me inform you that since the beginning, since the day it has been introduced in CFSL, CBI, New Delhi, voluntariness was protected. The subject's right to voluntary consent was protected so that he is not forced to be a witness against himself. Number one. Differentiation, yes. If you ask me personally, I am not for narco analysis. But I am for polygraph examination and brain mapping test. Yes.
Why so? Why so?
No, because you have to have some kind of investigating tool and you have to connect the criminal to the crime scene. How will you connect? There has to be some methods. Obviously, we are not going to take recourse of the old third-degree methods or so. Fortunately, means 10-15 years back when I used to take classes of the police officers, I used to hear that the best lie detector is the danda. But nowadays, because of the NHRC interference and awareness among the people, that third-degree method is not the constitutional.
And this is the way
thing.
out.
And this is the way
out. And you
out.
think this will compromise the
Yes.
tools that an investigator has?
Yes.
Yes, Sanjay.
If I could come in. See, the law has been amended in the Criminal Procedure Code. You can be compelled to give blood samples. You can give samples of your hair and other body substances. You can your handwriting can be subject to analysis. When all these are available, the question was,
why not?
Could we stretch this a little further and say what is inside the brain? If through a non-invasive method, that could also come within the ambit of the sections of the CRPC. The Supreme Court currently has said no. It's a 3-judge judgment. Maybe as time goes by, if the law requires a rethink, you could possibly amend the law, or possibly at some stage the Supreme Court may look at it again. But that would take time.
And ma'am, time for us to head into a break. When we come back, we will talk about the life-threatening impact of these tests. Welcome back. The Supreme Court in its judgment said that scientific techniques like narco analysis, brain mapping and polygraph tests have life-threatening impact on the person taking the test. The person exposed to such tests also suffers several undesirable medical side effects.
According to the judgment of the Supreme Court, there are health concerns of narcoanalysis test as the drug used is pentothal sodium. The life-threatening adverse effects of this drug leads to circulatory depression, respiratory depression, headache, retrograde amnesia, delirium, prolonged recovery, besides many other side effects.
So these are drugs are having narcotic effect on the brain and have effect on other systems of the body also, like in the respiratory system, like in GI, effect on eyes, effect on ear. So these causes short-term and long-term effect on the health of a person.
Let's look at the limitations of scientific techniques used by the investigators to collect evidence. In case of narcoanalysis technique, the person speaks in a drug-induced state and the person is not aware of his own responses at the time of investigation because he is in a hypnotic stage. In the polygraph examination and the brain electrical activation profile test, the person cannot anticipate the questions that will be put to him. The results are derived from the measurement of psychological responses, so the person cannot exercise an effective choice between remaining silent and voluntarily imparting personal knowledge.
It's a totally wrong thing that the Supreme Court did. That you can voluntarily say, I agree to do a test. If it is fake, it is fake. What difference does it make if I volunteer or I don't volunteer? And volunteering can also be taken by force. We know that. Police will torture you, police will threaten you and take your signature on a piece of paper.
The court in its judgment also recorded that India is not bound by the Convention Against Torture because despite being signatory to the convention, it has not been ratified by the Parliament.
If we take the gist of the judgment, it nowhere says to reform our criminal justice and talks much about limitations of scientific techniques. But there are reports like Malamud Committee report which suggested comprehensive use of forensic science in our criminal investigation. With camera person CV, Aruna Thakur, Rajya Sabha TV.
The narco analysis technique involves the intravenous administration of sodium pentothal, a drug which lowers inhibition on part of the subject and induces the person to talk freely. But the court says empirical studies suggest that the drug-induced revelations need not necessarily be true. Now that's the question. First of all, the impact of these, Dr. Lalwani, the impact of these drugs, especially the narco analysis, because that's the invasive technique and that's the one that is largely perceived as threatening, life-threatening. If it is so, what is it in your experience that you can tell us that actually has short-term or long-term impacts to life?
Yeah, as such, if we see, I perfectly agree with Dr. Gupta that a drug which is used, thiopental sodium or any other drug which can be used for this test has inherent effects, maybe adverse effect or you can say milder side effects. But the dose which we use in this particular test is a diluted one. It is not the drug, the dose which we use for induction of the patient to anesthesia. So it's a milder dose which is used to create a trance-like state, what we say as hypnotic state, where you can communicate with the patient. Patient is not in sleeping state or in complete anesthesia.
Okay.
So it is a second plane of anesthesia to what we say as hypnotic or trance state, where you can communicate with the patient. So in milder doses, definitely it may not be affecting the health, but yes, as far as medical practice is concerned, whatever medication we give to the patient, similarly, if we are giving thiopentone to this patient, it may affect the health of the patient because every individual is different.
What impact? What health?
Right, because this particular drug has effect on central nervous system, it has effect on cardiovascular system, it will affect your blood pressure, it will go down, heart rate will increase. Similarly, your mental conscious state is also depressed to certain extent with that. Other organs are also getting affected. But the advantage of this drug, why this drug is used in this, that it has get redistributed in the property of getting redistributed in the blood or in the body for very shorter time period, within very shorter time period. So it is not remaining in the blood for longer time period. It gets removed from the blood as soon as you stop infusion of the drug. So it is not remaining in the blood, so effect is very short lasting. But again, since it's a low plane anesthesia, where you can communicate with the patients, we have to take all the precautions. Like for any surgical process, we have to go for pre-anesthetic checkup. Here also, in this process, we have to conduct all the basic tests which are required to declare him fit to undergo this particular test.
Dr. Lalwani, if let's say an accused is aware that he is supposed to undergo this, he's already under duress and some sort of pressure, anxiety. Do you think in such a situation, actually making a scenario normal for him so that it can be administered to him, does it actually, is it a reality? Can it really happen?
Yes, actually, similarly, you see when patient is undergoing surgery, most of the time patient is declared unfit just prior to the surgery because his blood pressure is high or pulse rate is high, he is having some sort of anxiety. Because of that, a lot of complications are arising at the time of induction of anesthesia. So he is just asked to take rest for a few days and come back again. Okay. Similarly, here also, and sometimes if patient is little bit apprehensive, we take precautions. Like a day prior to the surgery, you give him some sort of a anxiolytic drug so that he is comfortable, cool, calm before the start of the surgery. So precautions can be taken. So that patient is not.
What's the shortest duration in which the chemical gets out of his blood system? What is the duration?
It's very short because.
How short is it?
I mean, within 10 minutes. If you say, if you see the graph of depletion of that drug from the blood, it is within 10 minutes. Okay. It has been reported in literature that within 10 minutes it is getting removed from the blood and it gets redistributed into various body compartments. So effect is not very long lasting. Patient regain consciousness as soon as your test is over and infusion of the drug is stopped.
Okay. So there is a middle path to it. On the voluntary consent, the point that was made by Mr. Colin Gonsalves, do you think that's relevant? Because according to him, he says there is one loophole in the system and the investigators can still use it, pressurize the accused to give their consent under force and show it as if it's voluntary and then make use of the result. Is that possible?
No, voluntary is purely voluntary. If somebody does not volunteer and if such consent is not recorded before a magistrate, then it is highly unlikely that anything obtained after such an examination, and if even primary evidence is discovered after such an examination, that evidence will be admissible. Consent is very important. Let us assume that the suspect is really innocent and wants to prove his innocence. You may recall that in the Talwar case, I think the couple even volunteered for a narco analysis, and it was in fact conducted. Correct me if I'm wrong. There were media reports to that extent. There can be a case where, say, a victim of child sexual abuse has suppressed the memory and has grown up into an adult. Many years later, that memory has to be retrieved. If such a victim is voluntarily subjecting himself or herself to a test and some evidence comes out, that evidence then can be corroborated. There are many situations where somebody could voluntarily undergo such a test. So the court is perfectly
But majority of the case, Dr. Ray, majority of the case, do you think consent is given the way Sanjay is describing it, or is consent given under pressure?
No, consent is given the way he is describing, because even if the investigating officers, they have pressurized the subject and brought him to us, we will ask him that even he says yes, yes, but still we ask and convince him, and we tell him every process, how we will examine him, what will be done, what questions will be asked from him. So, and then if he says that yes, he is agreeable to the test, then only we will subject him to
that. Is what
test.
What means by voluntary consent.
Voluntary
which
consent.
Essentially means being informed properly, a lawyer being present, a lawyer telling him all the...
If he wants the assistance of his lawyer, yes, till that time.
But the judgment says clearly that the lawyer should be present.
The lawyer should be present when such consent is recorded before a magistrate.
Before also, prior to this judgment also, if the person wanted that, I want to consult my lawyer, that time was given to him. He can come with the lawyer till he is giving the consent. But after that, the lawyer will not be allowed in the examination room.
Okay.
And secondly, it is not being conducted, the tests are not being conducted by the police officers. It is being conducted by the scientists who are independent. So
they have their own
ethics to follow, own rules to follow. So I don't think there should be
any problem.
It is not as if the policeman is sitting and saying, please ask this question.
I get the question. I get the idea. Time for us to enter into a break. When we return, we'll show you an interview with John Moses, Forensic Psychologist, Center, Forensic Science Lab. Welcome back. My colleague Aruna Thakur spoke to Forensic Psychologist, Central Forensic Science Lab, Mr. John Moses, and tried to get his point of view.
So there is a Supreme Court judgment which says that until and unless there is a consent of the person, there can be no scientific techniques like Narco analysis, polygraph test and brain mapping can be done on that person. So tell us your viewpoint on this judgment.
To some extent it is correct in respect of narco analysis and brain fingerprinting because it involves some injection of some drugs. But as far as polygraph is concerned, we are not injecting any drugs. And we will be connecting some sensors to the body of the person that will be measuring the physiological responses. We are not injecting any drugs or any needle is touching the person in fact. So I don't think it is that much applicable as that of this narco and brain fingerprinting.
So the judgment also talks in detail the limitations of these techniques, scientific techniques. Do you think that there are limitations to these scientific techniques?
I'm not sure about this narco analysis and brain fingerprinting. As far as polygraph is concerned, there are some limitations. We can say there are physiological limitations. For example, the person who is having erratic blood pressure and who is having epileptic fit, the pregnant ladies, for those persons we cannot conduct polygraph test. As far as the legal limitation is concerned, the minor persons we cannot conduct, and those who are not willing to undergo the polygraph test we cannot conduct. As far as psychological limitations are concerned, the person who is having below average IQ, for those persons we cannot conduct the polygraph test.
Do you think that these scientific techniques have any health concerns on the person when you apply to any person?
Not at all. As far as polygraph is concerned, it may be little bit inconvenient to the person because he may be asked to sit for more than an hour in a chair. But of course, it's a comfortable chair. No need to worry about it. There is no such side effects or anything is related as far as polygraph is concerned.
The court observed that there have been instances where the investigation agencies have leaked the video recordings of narco analysis interviews to media organizations. The court said, as these recordings expose the subject to undue social stigma and specific risks. Ma'am, the point you wanted to make on blanket ban, the judgment appears as if there is nothing of this kind can happen. All scientific tests come to an end. That is what people would assume. But what is your take on it?
All these three tests, means I am talking about the psychological tests, all these three tests cannot be clubbed together. Narco analysis, of course, is the invasive technique that can be separated from the polygraph test and brain mapping test.
And Sanjay, you wanted to make a point on compelling public interest.
I wish they had left a window open for compelling public interest. Let's take a case where there is a terrorist who you have caught and there is a bomb about to go off. In such circumstances, at least, narco analysis or something, if it could be done immediately to get at the truth, it should have been allowed. There are certain cases which have an emergency nature where if this is the only possible way, it should be held to be available to investigative agencies.
You were part of the entire argument type. Was this mentioned and do you think the court kind of overlooked this?
No, arguments like this were mentioned, but the court had to draw out a rule of law for all circumstances. And an exceptional case, I suppose the court assumed that exceptional remedies would be resorted to and the constitutionality could be gone into later at an appropriate stage.
On the basic medical examination before undergoing these tests, you wanted to make a point.
Yes, because physical health and mental health of the person is going to have effect on the procedural aspect as well as outcome. So, patient or person who is undergoing all these tests should be declared physically and mentally fit. So, thorough, proper medical examination is must before subjecting the person to all these three tests.
Is this happening, ma'am?
Yes, this is happening.
Okay. Thank you, sir, and thank you, ma'am, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.